Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Right, today I'm at Hervey Bay Magistrates Court. Client was charged with drug driving. There's two types of drug driving. The more serious is driving under the influence of a drug, meaning you are high on drugs, and the lesser charge is driving whilst a relevant drug is present, meaning that you consumed it at some point and it's still in your system, but you're no longer under the influence. My client was charged with the lesser of those two, so driving with a relevant drug present. There was actually two drugs found in his system, cannabis and methamphetamine ice. But again, he wasn't under the influence. It was the lesser of the two charges. When you're charged with that lesser offence, driving whilst a relevant drug is present, you are eligible to apply for a drug driving work licence. Simple eligibility doesn't equate to success, but as a starting point, if you have that charge, you are eligible to apply. One of the prerequisites for that eligibility is whether or not you've lost your licence in the last 5 years, which my client hadn't. But if someone has previously lost their licence in the last 5 years, they won't be able to apply for a drug driving work licence. But my client was eligible. Basically what I needed to do was, prior to today, draft lengthy affidavit materials. He was self-employed, so when someone has an employer, I do about a 4-page affidavit up for them to sign, talking about what they do, why they need their licence to do it, and that if they lose their licence, they will lose their job. But if that's in addition to the affidavits I draft for the client. But if someone's self-employed, there's obviously no employer or employer affidavit, but I do need to embed the client's business's profit and loss into the affidavits, as well as their personal income and expenses, family situation, difficulties they'll suffer while they're off the road, particularly in a regional location like Hervey Bay. What happened on the day in question. I got him to do a reformatory course. I spoke in the affidavits about what he learnt at that course, and I got him to get some character references based on a template that we provide all of our clients. As I said, I drafted those affidavits well in advance. I emailed them to the court to give the magistrate and the police the opportunity to read them prior to today. I drove up to Hervey Bay last night, met my client at court this morning, grabbed the conference room, signed all the affidavit materials, ran through the procedures, say what happens in the courtroom, what I'm going to say, what the police are going to say, what I anticipate the magistrate will say, etc. Again, I don't like clients to see and hear things for the first time as they're happening. I like to try and, not so much role play, but give them as much of a education as to what's coming prior to going in, rather than, again, them seeing it for the first time as it's happening before them. Worst case scenario for this charge, with no history, my client had no history, is a 9-month driver's licence disqualification. Mandatory minimum is 1 month. So again, worst case, if he had to come here by himself or with a lawyer that doesn't specialise, it's highly unlikely he would have got the maximum 9 months with no history. But I do see people in certain jurisdictions where they're not properly represented, not getting a lot of change out of around the 4 or 5 month mark for this charge. But again, the mandatory minimum is 1 month. With a drug driving work licence application, if successful, the magistrates have got the power to double what that otherwise gives. So technically, with a work licence, the worst case scenario today could have been 18 months, so a doubling of the maximum of 9. But again, that would, I've yet to see anyone get a penalty even without a lawyer of 18 months with a work licence with no history. But I do see people again failing in their efforts to get work licences when not only when they're unrepresented, but also when they've got lawyers that don't specialise. I mean, at the end of the day, you can't be an expert at everything. I mean, if you got me to do your conveyancing, someone in the Ukraine would end up owning the property, and that's why I don't do it. I specialise in drug, alcohol and traffic offending for that reason. I know it back to front, but like lawyers who know their respective fields back to front, they don't know my field back to front, and I don't know theirs. So that's why I specialise, and that's why it's a very good idea if you're going to get a lawyer to get someone who does nothing but what your current problem is. And I actually, as I said, do nothing but drug, alcohol and traffic offending. Anyway, back to what I was getting at. Worst case, as I said, 9 months, doubled to 18 with a work licence. Absolute best case scenario is 1 month without a work licence, and obviously, as I said, the magistrate's got the discretion to double what they'd otherwise give. Again, I drafted all those affidavits in advance, provided with the court well in advance. I don't like to put magistrates or police on the spot. I like them to be able to have as much time as they need to give a measured decision. So I'm assuming the magistrate read them in advance. But that said, today wasn't rushed. They did methodically take their time in reviewing the affidavit materials, as did the police, and I did guide the magistrate to the key points. But at the end of the day, when I draft my affidavits, the bulk of the work's already done. I mean, I've been doing this for a decade now. I know what magistrates do and don't need to hear. I've seen where other lawyers and unrepresented persons have fallen down. I've factored those sort of lessons, for want of a better word, into the affidavits that I draft. So my affidavits are basically at a point where any and every sort of hurdle, for want of a better word, has already been addressed before it presents. So, for example, one of the ways people fall down with work licences is if you're caught whilst driving for work purposes, drug driving or drink driving, that's an immediate disqualifier for work licence eligibility. So if the police brief says, the person admitted they were driving for work purposes, or, you were driving a vehicle with signage on it, clearly driving as a part of your role, that will stop you dead in your tracks. That said, the case law is all over the shop, but I've basically over the years I've gathered various cases that support the notion that driving to and from work isn't necessarily work purposes, because you're not actually paid to drive to and from work, and you're not actually doing your job. And I mean, the example is a train driver. A train driver might be driving a Queensland Rail vehicle to work, and the client today wasn't an employee of Queensland Rail. I'm simply using a hypothetical scenario here, but just because the vehicle's got Queensland Rail written on it and the client's driving to a train station, they're a train driver, and driving to a train station isn't driving a train, if that makes sense. So again, the case law is all over the shop. Some magistrates are of the view that work's work, and they take the the personal injury work cover sort of approach of, with work, I'm going off point, but if you get injured travelling to work, you're covered by work cover, because in their mind you're on the job. Whereas my argument is based on the case law that if you're not actually engaging in the act of your job title, you're not driving for work purposes. And I've, on every occasion where I've been challenged, managed to get it over the line and persuade a magistrate that, unless the person's actually driving a train, they're not driving in the, conduct of their job or employment. Anyway, I'm prattling on a bit now, but what I'm getting at is, the short version is I was successful. I was able to persuade the magistrate to grant my client's drug driving work licence application. He received a modest fine, and I guess based on the contents of the affidavits, my verbal submissions, his lack of history, and the fact that he'd done that reformatory course, in addition to being successful in applying for a work licence, the magistrate did not exercise their discretion to double what they'd otherwise give. So the short version is he got a 1 month disqualification. So 1 month disqualification, work licence overlaps it. So for work purposes, he's literally hasn't lost his licence. The only thing he can't do in the next month is, fishing or, taking his missus to the movies and that kind of stuff. But as far as earning a dollar goes, no change, no loss of licence. Obviously, he's very happy and relieved. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment, or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road.